Well, good afternoon, America. This is Clark coming to you live from Las Vegas, Nevada. Special little broadcast today on YouTube that'll be seen all over the world. And I'm making this in honor of a very despicable bank called People's United Bank that needs to be exposed for what they are. They are a criminal enterprise that has stolen money from the dead. And they go to the top of my list of someone that nobody should ever think of doing business with, and I'm going to see to it that that word gets out there. Anyways, it's now time to, it's arrived that the Martha E. Feeley real estate cashier's check issued by People's United Bank be paid, honored and paid to the remitter, the holder and trustee, me, Clark Feeley. There's a picture of the check right there, issued by People's United Bank. People's, it was signed by Travis Coloni, the manager of said bank. And on this cashier's check, there's a little notice here to customers I'd like to read to you. Of course, the bank people may know what this says. Of course, I don't know what this bank knows. They seem to be very incompetent to a certain level, to a great level, actually. Notice to customers, the purchase of an indemnity bond may be required before this check will be replaced or refunded in the event it is lost, misplaced, or stolen. How about that? That's the only thing really on the front of this check that indicates anything about some sort of thing that may have to be done if this check should be lost by me. I'm the remitter. I'm the one that got this check put in my hand by this Travis Coloni, manager of that branch. So technically I'm the only one that can go back to the bank and say, hey, I lost the check. What can be done about it? According to this statement here, they may require me to put up a indemnity bond. So if you're somebody that's buying a cashier's check, you're supposed to be guaranteed a couple things by the bank. One, that check there, that replacement, or this check that they give you is actually has cash equivalency. You gave the bank good funds to buy this cashier's check, and they gave you this, which is more safe to carry around. That's what Travis Coloni said to me when I purchased it, that I asked for cash. He said, why would you want to carry around that much cash? Why don't you just get a cashier's check? It's the same thing, has cash equivalency, and it's cashable anytime you want. So I guess that made more sense to me than carrying around $1.5 million in cash. That is a little silly. So being that that's what a cashier's check is, they're accepted all over the world. They're very important to the business of commerce because any kind of time you have a closing or you're buying something or something's coming to a finality and you have to pay for whatever you're purchasing, and the person that you're buying it from wants to have to be paid before they give you the thing you're buying, cashier's checks are used for that purpose. More than anything else, really. Money wires don't work because someone would have to wire the money before you actually got what you're buying, and that's kind of dangerous. So cashier's checks are the instrument that's used all over the world. You're buying something, here's the check, here's my deed, there we go, down the road, everything's copacetic. So that means that banks have a very big obligation. Not really. They got paid for this when I got it. Before I got it, they got paid for that. Their only obligation now is to pay for this check. That's it. They have to pay for it when I present it. That's as simple as that. Bank officers and so forth have a requirement to do their job. Pretty simple stuff, really, when you think about it. There used to be a guy pretty well known around, became a legend. That's Willie Sutton. He's known as one of the America's biggest bank robbers, most famous anyways. Somebody asked him one time, gee, why do you rob banks? And his reply was, because that's where the money is. Well, Now it seems like Willie Sutton may have been replaced by bank officers such as Jack Barnes, Robert Trotman, John Egan, Dan Carone. These are all People's United Bank officers that, for the moment anyways, have more or less stolen this cashier's check funds that they had in their possession. To honor this check, they decided to not honor the check, and instead what they did is even worse than not honoring the check, because they've got themselves a big problem now. You guys, are you listening? Jack Barnes, everybody, Robert Trotman, how you doing? John Egan, you're a real winner. You told me a long time ago that you considered this matter closed. Well, does it sound closed to you, Mr. Egan? You work for a legal department, which I think the bank should consider something very important. You might want to get that name a little more accurate as to what your department there at the bank is. Why don't you consider RICO department? That would probably be a lot more accurate than calling it a legal department, because when you stop payment on a cashier's check, you're anything but legal. You're illegal. And when you participate with a corrupt court in a state such as Nevada that's known for its corruption, you're participating in a scheme yourself. And the scheme is to convert funds that belong to a trust. This check is made out to the Martha E. Feeley Real Estate Trust. You are taking money that's held in trust, created under the laws of New Hampshire and governed by the laws of New Hampshire, where your bank branch was and where Travis Coloni works in Wolfboro, New Hampshire. You're taking that money and you're participating in a scheme with Las Vegas court to, I guess, that what the court was doing was trying to pay their lawyers. And in Nevada, they have a system out there where all the judges are elected. And that means they have to raise campaign contributions. And where do you think the first parties are that they go to raise capital for their campaigns? They go right to the lawyers that are dependent upon working with the judges in their courtrooms and relying upon whatever orders or decisions or judgments they're able to wrestle from the judge. Now, gee, don't you think it might be advantage to those lawyers to maybe participate a little bit in funding the campaigns of those judges? What that creates is extreme corruption. Now, at least half the states have seen the wisdom of going to a more or less appointed basis on a merit-based system rather than have campaign contributions made to judges, because that's just an absolute invitation to corruption. It's worse than that. It's stupid. Okay? Connecticut doesn't elect their judges that way. Neither does New Hampshire. But the brilliant officers there, Jack Barnes, you're in charge. You're the CEO. You have your RICO department decide to send money to Nevada so that the judge out there can reward his campaign contributors in his court to pay money that actually comes from dead people. My mother and father have died, and this represents the property that they owned on Lake Winnipesaukee. For 50 years, the Feeley family has owned this property. And the bank, through the brilliance of Mr. Jack Barnes and others, Robert Trotman, don't want to leave anybody out, John Egan, Dan Carone, who seems to have disappeared from at least the bank area of employment. Gee, I wonder why. He signed that stipulation agreement that we'll talk about in a minute. But anyways, the bank participated in a scheme to steal money from the dead and allow a judge, a corrupted judge in Nevada, to donate that money, award it to his lawyer friends that can turn around and contribute to his campaign. And you call yourself a bank. You know, Willie Sutton would be proud. You guys have taken over for him. You know, now you do it. You don't need a gun or anything else. You just steal money from your customers and you call yourself a bank. How are you going to get away with continuing to portray yourself as a bank? Don't you know that your reputation and what you are supposed to be anyways is very important to your customers? How about to your stockholders that invest money in your bank? They're investing in your reputation. How about that? What do you think your reputation is going to be like when you get associated to a RICO Act violation with a corrupted court. And why do I say this? Why do I bring all these things up in the way I do? Well, let's go into this stipulation agreement a little bit. It's quite the piece of work. John Egan had a lot to do with this, and the court out here in Nevada, when I sold the home back there in New Hampshire, I did it for one reason, really, because this out-of-control judge who was making illegal rulings dictated that the home be sold, and he dictated that the losing defense attorney out here in Nevada be involved in the sale to arrange for a broker to sell this property. Well, when I heard that, I'm the trustee of this particular trust, I went dashing back to New Hampshire and I sold the house because I couldn't allow this despicable criminal attorney to have anything to do with working some kind of a deal with a broker in New Hampshire to sell a house that they have no authority to do that. You can't, one court in any state cannot control property with citizens in another state. That's just the way it is. Everybody knows that. Why doesn't your RICO department at your bank under John Egan and Robert Troutman, why don't they know this? I mean, are you kidding me? You know what it means? It means to me that somebody at the bank got an envelope full of cash or something. And I think the records are going to show that that envelope was delivered by one Mark Derby, who works for Cleveland Waters and Bass out of New Hampshire. And he actually works for the firm, believe this when I say it, because it's true and I can prove it. Mark Derby's firm, Cleveland Waters and Bass, developed the trust agreement, this Martha E. Feeley trust, real estate trust. That firm created that trust, basically for a single reason, and that is to protect the property, the assets, for the beneficiaries. And this law firm participated in the very scheme that I'm talking about. They represented to the bank, People's United Bank, that this check needed to have payment stopped on it. They induced you to stop payment on that check. How do I know that? I have right here the inducement motion, or a motion to the probate court there in New Hampshire, where Mark Derby apparently was the lawyer that had Wanda Feeley, my sister. She was a thief that was stealing money from the trust that caused all this stuff to go on. My mother had two trusts. One had money and stock documents. Another trust had this home here, the real estate trust. Anyways, Mark Derby, working for the firm that created the trust for my mother and the benefit of the beneficiaries, used one of the beneficiaries, my sister Wanda Feeley, to represent this case, apparently, against People's United Bank. Wanda G. Feeley versus People's United Bank. And that's case number 312-2013-CV-239. That case is represented that Wanda Feeley is the plaintiff. Well, Wanda Feeley, at the time that this case apparently was filed, was not the trustee of this trust. Okay? Wasn't a trustee of anything, because she'd been removed from Nevada court because she was stealing money out here in Nevada from the trust. So that's not a very good person to have as a trust. Matter of fact, the judge in his ruling claimed that she was not competent to be a trustee. Completely bananas, but not bananas, but she's just not competent, and she's a fool. Anyways, she allowed this Mark Derby, who's a specious criminal attorney there in New Hampshire, to represent her in a suit against the bank. And what the suit, I guess, was over was, everyone's hiding the suit from me. They won't give me access, not even the court. They've been hiding these types of documents from me for a long time. But anyways, apparently they were using Wanda Feeley to, as the plaintiff, to force the bank to stop payment on a cashier's check and send the money to Nevada. Now, to pay these lawyers, out in Nevada. Now, if you had a brain in your head and you were a beneficiary of a trust, why the hell would you ever sue a bank to have them send your money that's held in trust for you to another state that doesn't have jurisdiction to reward the attorneys that turn around and contribute the money to judges in their campaign efforts to be reelected? Why in the hell would you ever do that? Why in the hell would a lawyer from New Hampshire that created the trust for your mother to protect your interest, a spendthrift trust, by the way? The reason for a spendthrift trust is because of fools like Wanda Feeley that can be taken advantage of by a despicable lawyer like Mark Derby that created the trust for the very family that you're saying to the bank, give the money to Nevada, let the judge give it away to the lawyers. I mean, first of all, Wanda Feeley has no standing to sue the bank in New Hampshire. Why doesn't your crack RICO department, Mr. Egan, Mr. Troutman, Mr. Barnes, the CEO, why don't you know these things? Why is your department so lame that you even involved in a suit like this? The more important question would be, why am I trying to contact the bank and go over these things with you, and you're refusing to meet with me, you're refusing to talk to me? Matter of fact, John Egan's telling me that they can't talk to me because I'm not the trustee. Who in the hell told them I'm not the trustee? And who is John Egan to tell me that I'm not the trustee? I have this cashier's check. I bought this cashier's check from Travis Coloni with money as the trustee of the Martha E. Feeley Real Estate Trust. That's why I have this check. Okay, Mr. Egan, you consider the matter over? Well, it's just now starting, really. So get that through your head. But you're sending me emails like I'm in receipt of your email to our general counsel, Robert Troutman. Please direct any correspondence to my attention, as I am your point of contact within the bank, and you will not receive any further response from Attorney Troutman. Oh, well, thank you very much, Mr. Egan. Sorry, Mr. Troutman, for even addressing the situation of you being general counsel of the bank, and I'm holding a cashier's check from your bank written to me for $1,340,000, and your bank is refusing to pay it, which is illegal. And I can't talk to you. You're not going to talk to me. You're going to have me cut off by this John Egan. Well, sorry, I'm back, Mr. Troutman, and maybe I'll have you on the witness stand in front of the jury, and we'll see how far this goes and whether you're going to talk to me then or not, okay? But as a courtesy, Egan goes on, I've attached a copy of the restraining order that prohibits us from cashing the cashier's check in your possession. How do I have the cashier's check, Mr. Egan, Mr. Troutman? How do I have this check? Because I paid money for it, and I got it as the trustee of the trust. So I have every right to cash this check. That's why Travis Coloni gave it to me. I asked for cash. He said, you don't want cash. That's dangerous. Just get a cashier's check. Well, I got a cashier's check. Now, once you have this, it's considered cash equivalency. So, when you say that you got a restraining order that prohibits you from cashing this check, how do you get a restraining order? And where did that come from? And just for your own information, a restraining order is a freeze, if it's even valid, which it isn't in this case, but even if it was valid, or an enjoyment, or whatever else you refer to as this case goes on, is a freeze order. It's a freeze. It doesn't tell you to send the money to Nevada. Where does that order come from, by the way? What order are you referring to that you sent the money to Nevada? Where does that order come from? First of all, it can't be an order from an out-of-state court lacking jurisdiction. Where does the order come from? Does your RICO department realize that states have sovereignty? That New Hampshire has sovereignty? Connecticut has sovereignty? How do you send money that's held in trust to another state? How do you do this? Where's the judgment? There was a case out here in Nevada that's just now really being determined, if you will, because I appealed it. And there was a case out here, but it was a case to remove my sister as trustee because she was stealing money from the money trust. That's why she was removed, and she was removed. So I'm the prevailing party in the Nevada litigation. I am the judgment creditor. So where's the order telling you to send the money to Nevada? Well, let's get into it. Maybe you're referring to this stipulation agreement that the bank entered right here. This is really a classic document here, the stipulation agreement. This was dated August 20th, I think, of 2013, and this is a real piece of work. When I sold the home and got this cashier's check, the judge out here in Nevada and the lawyer that was trying to get paid $600,000, the illustrious Howard Reutemann, who you've had a lot of communication with, I guess, with the bank, and then he's the one that hired this Mark Derby, another specious snake, to help him steal the money from the bank. And anyway, this stipulation agreement, your RICO department, Egan had a lot to do with this, because I have records where there were things going back and forth between the bank and a court appointed out here, Nevada court appointed without jurisdiction, appointed a trustee because the judge needed a trustee to be able to steal the money, and he can't use me because I wouldn't do it. I had an obligation to protect the trust. So he appointed another trustee. He thought he did anyways. He didn't have jurisdiction to do that, and he didn't have jurisdiction to remove me or authority because I hadn't done anything wrong. He couldn't remove me anyways because this is a New Hampshire trust, and I hadn't done anything in Nevada to worthy of being removed, other than I refused to give him this check, rightfully so, because the law is that the trustee has to protect the trust, especially a spendthrift trust, from anybody that's trying to attack the trust, including courts. Courts do not have authority to do anything about a spendthrift trust. And the reason for that is, I'll tell your RICO department if they're listening, a spendthrift trust, the bottom line is, nobody owns anything. Everything is being held in trust. And the only person that can disperse any money, according to the terms of the trust, is the trustee. They can't disperse money to the direction of a court because the court can't tell the trustee what to do with the money. Only the settlor, the person that created the trust, can tell the trustee what to do with the money, and they do that by words in the document because they're dead. So a judge can't intercede and affect the trust. If they could do that, there would be no reason to have a trust. Why would anyone have a trust if some judge that wants to pay a lawyer an obscene amount of money so he can contribute to his campaign? Why would anyone have a trust? Doesn't somebody in your RICO department know this? Don't you think that way? Maybe if Egan had listened to me a little bit and not try to get rid of me with these phony emails, saying, don't talk to Treutman. Well, maybe if Treutman did talk to me, maybe if somebody listened to me for once, they would at least get the other side of the story. And I can explain these legalities to you. I can explain who Wanda Feeley is and how she couldn't sue you. And you pay attention to her suit, and then you send money to Nevada because of this suit from a judge who has no jurisdiction to do anything. You pay attention to a restraining order preventing you from paying a check. The restraining order came after the date of the check. The date of this check is June 26, 2013. This restraining order, you got something against the bank account on June 27th, but this check had already been issued. But what you got then was just an order saying to freeze the account. And you sent back a disclosure agreement saying, we don't know what this account is yet. We have to look and see if it might be exempt. What happened to that order? What happened to that disclosure agreement? What transpired there? Didn't somebody in your RICO department notice? Wait a minute, this is a trust. We can't do anything with a trust. I don't know what kind of people you have running your RICO department there, but you better consider making some changes. Your board of directors, I hope you all are listening. You're going to get a copy of this, by the way, so you can see this great movie we're making here. If you're interested, I mean, you sit on a board of a bank, you better start paying attention because your bank's going to get associated with a RICO action. And that's kind of serious, because that's not good when a bank gets involved in that stuff. Anyways, this stipulation agreement here, this is a real doozy. You can be proud, Mr. Barnes, of your crack RICO department when they come up with something like this. And this took months to develop this agreement. This is billing records from Howard Reutemann. This is one of the criminal lawyers out here. This is one of the guys you were negotiating with in this agreement. John Egan was. and the terms of this agreement, it's just wonderful. You know, I have his billing record. I have all these records that show back and forth, back and forth. Oh, the bank has a concern about this line here. We need to change this line because, you know, so what you're doing is you're massaging the language of laws, like UCC regulations, and you're trying to get around them so that you can somehow do this deal. And what the deal came down to, and what the stipulation agreement basically says, is the check has been lost, destroyed, or stolen. This check right here, this check right here that I have in my possession has been lost, destroyed, or stolen. And you know what? You get an order from the judge out here in Nevada saying to approve this stipulation agreement because the check's been lost, destroyed, or stolen. How do you do that? You know. The problem is, you know that the check's not lost, destroyed, or stolen. John Egan knew that. John Egan sends me an email. The check that you have in your possession, dated October 17, 2013, right here, the check that you have in your possession is no longer any good. No longer valid. Also, please note that pursuant to court order, the proceeds of the check were redeposited into the trust account and were then turned over to the court-appointed receiver for the trust. If you have additional questions or concerns regarding the trust assets, you should address them to the receiver. You know who the receiver is? Howard Reutemann, the defense attorney that lost the case when my sister got removed as trustee. He's the loser, and the judge appoints him as a receiver. You know why he appointed him as a receiver? Because the trustee that the judge picked to appoint over me, which he can't do because I'm named in the document. You can't just replace someone named in the document, especially without cause, especially for holding on to an asset of the trust to protect it from attack from a court. I have every obligation and every right to do that. But anyways, Howard Reutemann, this guy here, was appointed receiver because the trustee that the judge appointed to replace me, if you will, refused to sign the stipulation agreement. Why? Because he's a CPA, and he knew that this stipulation agreement that he helped negotiate, by the way, when he came downtown to sign it, he wouldn't sign it because he knew it was an illegal document. So the judge, being the judge that he is, completely illegal, just appoints his losing defense attorney who was trying to be paid some $600,000 out of this money here for this cashier's check. He ended up getting paid $400,000 because the illustrious bank, through the guys of Barnes and Trotman and Egan and Dan Carone, decided to send the money to Nevada. Let that judge out there pay all his lawyer buddies so he can get reelected. You guys are brilliant. You're really, really brilliant. The worst thing you did, though, you participated in a scheme like bank fraud. 18 U.S.C. 1344. Any scheme that attempts to get money from a bank under any false premises, like maybe a check being lost, like this check up here being lost, this check right here lost. No, it's not lost. And you knew it. The bank knew it. So you're complicit in this scheme. Now, how do I know you're complicit in the scheme? Let's go to number 2 on page 2 of this stipulation agreement. This is dated August 20th, 2013, by the way. You should have a copy of it. If not, call me and I'll send you one. Anyways, Peoples will immediately notify Mr. Reutemann. Oh, of all people. They'll notify Mr. Reutemann and the New Hampshire Council, the snake Mark Derby, for Wanda G. Feeley, the beneficiary who's posing as some kind of person suing the bank that's only a beneficiary. She has no standing to sue the bank. And Mark Derby mentioned in here, Cleveland Waters and Bath, the Peoples will notify them immediately should the check come through from a financial institution or whatever presented for the bank to pay. So the bank is going, People's United, you have this in this document. You're not going to pay the check. You're going to keep the check. You're going to hold on to the check, and then you're going to tell the bank that it came through channels, the clearinghouse, whatever. You're going to tell them to contact Howard Reutemann, chief perpetrator, thief perpetrator in chief, and Mark Derby, another snake lawyer who induced the bank to do this. So he's a criminal. It's a Class A felony under 18 U.S.C. 1014 to induce a bank to not honor a commitment. Who in your RICO department doesn't know that? Hello, Mr. Egan, are you listening? Troutman, anybody? Barnes, how about you? Anybody there listening to me? It's about time you did, because every day that goes by, you're getting deeper and deeper and deeper. And it's not going to come out well for you. What you need to do is start listening and start paying attention. That's what you need to do. Getting back to the stipulation agreement. This stipulation agreement is between the court-appointed receiver, the chief perpetrator, the thief perpetrator in chief, and People's United Bank. Okay, first of all, you can't have an agreement with a trust because a trust is not an entity in New Hampshire or Las Vegas or anywhere else. And this receiver, this supposed receiver, is not a valid receiver because the only one that could enter anything for a trust is a trustee. And the only trustees available to this court, which aren't even available because they're all illegal, nobody has authority to do this. And worse than that, because this is based on the check being lost, which is right here, is not lost. The only person that could sign a affidavit declaring that the check is lost per Connecticut statutes, because you're headquartered in Connecticut. Travis Carloni told me that the officers of his bosses were not allowing him to cash the check that I presented to him to be cashed. He refused to cash it, saying his bosses told him not to. Well, there was a branch in New Hampshire where I went to, but the headquarters of the People's United Bank is in Connecticut. That makes this a Connecticut issue. Here's a Connecticut statute regarding UCC regulations that they passed and enacted. And if you're going to take an affidavit, which you're required to do, remember this indemnity bond stuff here on this check and all that language? Well, before a bank should ever consider issuing another cashier's check to replace one that's been lost, destroyed, or stolen, you need to get yourself an indemnity, or you need to get yourself an affidavit signed by somebody that claims they lost a check. Now, the first line of this law, this statute, the person was in possession of the instrument and entitled to enforce it when loss of possession occurred. This is the Connecticut statute regarding the UCC regulation, 42A3309. Now, the affidavit that was accepted by Dan Carone, who signed the stipulation agreement, he accepted this affidavit signed by our buddy Howard Reutemann. In that affidavit, he declares that he had possession of the check when it was lost, destroyed, or stolen. Our illustrious Judge Alan Earl out here is the Nevada judge that signed an order dictating that Howard Reutemann enter this agreement, sign it, and have Dan Carone, this other clown from People's United Bank, sign it and accept the fact that this affidavit is fraud. Everybody at the bank knows the check is not lost. This paragraph that you have here in this stipulation agreement, where the bank says that if the check should be presented through legal channels like the clearinghouse, in other words, I deposit at the bank puts it in for payment, you're going to hold on to the check? How do you do that? And you're going to tell the bank that deposited the check to go call Reutemann, one of the thieves? How, I don't know, Mr. Egan. Mr. Troutman, I don't know. You need to have the board of directors seriously look at your qualifications to see if in any respect you're qualified for your position, because I don't see it myself. And this stipulation agreement's a joke. It goes on, it's just amazing. There's so many things in here that's out and out just pathetic. You took the position for a while. I guess you kind of got off of it, but Egan was telling me that they've been enjoined from paying this check. Well, UCC 4303 is a UCC regulation that has been adopted and passed by all states, most states. Connecticut's one of them, New Hampshire's another one, that states that any order coming in from a court affecting a cashier's check that's already been issued comes too late if the check's already been issued. Cash equivalency and all that, you know? So all these enjoyments and everything that your esteemed Egan likes to point to are all invalid. They don't mean anything. Doesn't someone in your RICO department know that? Hello, Mr. Egan, you would refuse to even respond to me about 4303. You said I was grossly mistaken, or I was out in Neverland. I think you used some kind of word like that. I have the document. I can send it to you. I'm sure you have it too. But you used some language there when I contacted the OCC about this, that I was in Neverland. You don't know what I'm talking about. Look it up. UCC 4303. Go to one of your handy dandy computers. I'm sure you have one lying around there. Just type it in a search engine like Google. Type in UCC 4303. It'll come right up. Boom, there it is. Bam. Read it. Any check, any order coming after acceptance means for you RICO people in that department there, any acceptance is issued. Upon issuing, you accept the fact that that check is as good as cash because you're going to honor it when it's presented for payment. That's what you have to do. Anyways, I went and I filed a case in District Court in New Hampshire, the U.S. District Court there, regarding this cashier's check. And I filed that, I don't know, sometime in April of 14 or whatever. Anyways, very funny rulings you get now and then. Anyways, I got one from the court there. They dismissed the case. They dismissed it on a lot of irrelevant technicalities that don't really apply and are not relevant anyways. But, you know, you get rulings like that now and then, and you wonder why in the world would the judge say things like this? Like, he points to the fact that the order has not become effective yet. How can a bank stop payment of a check or not issue a check because the enjoyment hasn't become effective yet? So you made a check, you gave it, unbeknowing that the check's, an order's going to come. The judge couldn't find any basis for that. Why doesn't he go to his handy-dandy computer, look up 4303, and he'll find it, just like I told you to do, Mr. Egan. But the reason the judge didn't do that, and I put this in all my briefs, all my paperwork that I filed with the court, had 4303 in there. It also had another very interesting clause, and that's cash equivalency. I also submitted probably at least 50 precedences that cashier's checks cannot be countermanded. They can't have payments stopped because they have cash equivalency. I brought that to the attention, brought it to the attention of that judge in New Hampshire, and he ignored it. Now, when you see something like that, why doesn't the court just address it? If they want to give me an answer why that doesn't apply, address it. But when they ignore it, what does that mean? To me, that means that court's fixed. So I started looking into that court, and I find out that there was a court case against People's United Bank called Petco. I'm sure someone there at the bank's familiar with that one. How about you, Mr. Barnes, Mr. Troutman? Anyways, there was a case called Petco, and that went before the U.S. District Court there in New Hampshire, and the court ruled, oh no, you're defending People's United Bank, you're not, you know, they found you okay, no problem at all. That concerned a fact where you paid money out of someone's account to the wrong person. So that's another great thing that y'all did. But anyways, you won that one, so great, you know, and you wonder
how the hell? I read that ruling, I'm going, there's something wrong with this court, you know? Well, Patco ended up going to the First Circuit, and they appealed. And the First Circuit said, whoa, wait a minute, this ain't right. And they found in favor of Patco, vacated the U.S. District Court's ruling. So there seems to be a history there that maybe the court is fixed in New Hampshire. I'll say it. Have them explain to me why I point out 4303 to them and they ignore it. Why do I point out cash equivalents to them and they ignore it? Why do they do that? It's because it's fatal for them. That's why. They can't rule in your favor, and you're the one that asked them to rule in your favor. So anyways, right here in my hand, I have an excerpt from a case that went to the First Circuit. This is a case over a cashier's check that was issued from the Banco de Santander of Puerto Rico. Now, this is a case that's pretty famous in New Hampshire. You can look it up. First Circuit. I think it's Saenz, S-A-E-N-Z versus Banco de Santander. Anyways, in here, item number 14 is very interesting. It says, similar commercial policy considerations have persuaded courts in other jurisdictions to conclude that a bank may not countermand its cashier's checks once it has been delivered. Relevance of decisions in other for the Seventh Circuit was presented with an analogous case in Munson, which involved a bank's attempt to countermand its cashier's check when the draft tendered as consideration was dishonored. So someone bought a cashier's check with a no good check, and the bank issued the cashier's check, assuming, I guess, the check that they got was good. When they found out the check wasn't good, they said, whoa, and they tried to stop payment on their cashier's check. Well, this court, the Seventh Circuit, said, sorry, bank, you never should have issued the cashier's check until you found out if it was good or not, because cashier's checks have cash equivalency. It's extremely important. That's an event, bam, okay? That's as good as cash. The court goes on to say the bank has no more right to countermand its cashier's check than to refuse to pay cash it had already paid. How do you get cash back if you already paid it? I asked Travis Coloni for cash, remember? He said, oh, get a cashier's check. It's much safer. Okay, well, anyways, apparently all the laws you read and everything else, it is safe. Travis was right. The problem is that his bosses there in Connecticut had told him not to pay it are crooks. And they fall under the RICO Act because they're such crooks. Not because I'm just using that word, because you participated in a RICO Act with a stipulation agreement. You're complicit. You say that you're going to hold the check should have come through channels. This lost check that you know is not lost. You know it wasn't lost when you signed this stipulation agreement. You know, always have known it's not lost. That's corruption. That's RICO. Racketeering, influence, corruption, organization. You fall right into that. So explain that to yourselves. Explain that to your stockholders. Explain that to your customers that rely on the integrity of the bank. Explain that to the banking and commerce industry out there that rely upon cashier's checks. This isn't just about Feeley, okay? Let's get over that and pass that one, all right? You're going to have to pay this check. The sooner you pay it, the better, because you're having fees, expenses, interest mount up daily. So get that through your head. Are you stockholders listening? I'm sending this to you too, so you better listen, because every day you're spending interest, and every day the damages mount. And when you start talking treble damages, you're talking a lot of damages. and they're reliable damage. I mean, these damages have occurred. So this isn't some kind of phony speculation. Every day that you don't honor your check, you're causing damages. Not only to Feeley's family trust, but you're causing damages to the entire banking industry in the United States, probably the world, because banks rely upon the fact that they can sell these cashier's checks. And that's part of what they sell. That's a product that you all sell. The court here, First Circuit, which is the controlling, they're the ones that ruled against you in Petco. You're familiar with the First Circuit, I'm sure. You listening, Mr. Barnes? Like Chase Manhattan, Kaufman versus Chase Manhattan. Another one, the bank loses. The bank always loses, by the way. Case with the bank, actually, in facts like my case, ever prevail, never. Now, First Circuit, the cashier's check transaction is not executory, but rather an executed sale. Do you hear me? That cashier's check right here, that thing that I bought from Travis Coloni, your branch manager in New Hampshire, when I went to cash that check to him personally, he refused to cash it because bank officers in Connecticut were forbidding him to cash it. Okay, well, again, First Circuit, the cashier's check transaction is not executory, but rather an executed transaction of purchase and sale. Now, the state of Connecticut has seen the wisdom to pass an act, kind of reflected on the FTC act that they passed, number 5, which is a Consumer Unfair Trade Practice Act. Well, Connecticut has the same thing. You have a bank in Connecticut, you should be aware that you're a business in Connecticut. You warrant these various things. You sold me a product, this cashier's check, and you warranted to me that cashier's check would be paid in cash because I gave you the cash to honor that check, and you have an obligation to pay it. So, I bought from you that document, this document right here, that cashier's check. You see it again? You can look up a copy. I'm sure you got a copy of it. Check number 7738735, signed by Travis Coloni, manager in Wolfboro. Call him up and ask about it. He knows me very well. He'll tell you. But anyways, I don't think that's in dispute. I think everybody knows that I have the cashier's check. I know they know that I've always had it. I've certainly communicated that to not only John Egan, I communicated it to Robert Troutman. Barnes goes, Jack Barnes, thanks, Jack. Back to me. I sent you an email, never heard anything, not a word. I spelled all this out to you in about a 2-page email on the 20th something of April in 2014. Never heard anything back to you. I got a letter from, an email from John Egan, stating I gave him an option to Travis Coloni. I said, you can pay this check. The bosses that you're referring to that are refusing to pay the check, you can have a meeting with me and we'll discuss it, or I'm going to sue you. Well, John Egan sent me a letter saying that they don't see any reason to meet with me at this time. That, well, I just said I'm going to sue you if you don't meet with me, so that's no reason to meet with me? Okay. Well, at the time, I guess I didn't know that the fix was in the courts around there, that they're going to rule in your favor. I found that out for a nefarious reason, I guess, because the court didn't have any reason to rule against a black and white issue controlled by UCC regulations that have been enacted in New Hampshire and Connecticut and everywhere else. You have to pay a cashier's check. That's not an issue. You have to pay a cashier's check. And a cashier's check that you were given good value for, like in this case, you have to pay it. You can't raise a defense that I'm not this or I'm not that, because those defenses don't work anyways. Because the fact is that the court out here in Nevada had no jurisdiction over this issue. And why have I been so quiet for a while? I've had an appeal here pending in Nevada, and they just ruled on my case this last January. And it was an appeal court, which I had filed an appeal with the Supreme Court, but after I did that, an appeal court came into play here in Nevada, lower court really, and the Supreme Court knocked it down to the appeal court. The appeal court, real job is to protect the lower courts, and that's their propensity, so we say. So they struggle sometimes trying to protect courts. But I knew, I've been waiting for the court to rule on this, because this is a black and white issue. The issue, the law of the land, based in the Constitution of the country. Here again, is the RICO department listening? John Egan, are you listening? Robert Troutman, he's supposed to be general counsel. Are you listening? Because this is fundamental 101 when it comes to law. No state can make any ruling. They're completely without jurisdiction to make a ruling concerning property located in another state. Well, this situation here in Nevada, where the judge tried to maneuver around all these trusts and everything else for the sole purpose of trying to find money so he could pay his lawyers so they could turn around and contribute to judges' campaigns. That's what this became all about. And everything was maneuvered. Everything became a big entanglement, a big cluster, if you will, because they're trying to get around laws. Well, they can't get around that one. You know why? Because the property that this judge dictated to be sold, this real estate trust, is a New Hampshire real estate trust. It's a trust created and governed by the laws of New Hampshire. So it has to be the only people that have exclusive jurisdiction over this trust is New Hampshire. And New Hampshire made a ruling in the probate, if you call it a ruling, with a stupid order, and it was obtained by that specious Mark Derby by lying to the court. The probate judge, a one-day-a-week judge who doesn't know his ass from his elbow either, made a ruling, oh, no big deal, right? He just said that a court in Nevada has assumed jurisdiction over the administration of a trust. Ah, okay. Well, that, of course, means everything when you're a lawyer trying to get around laws. But administration is personal jurisdiction. It's not choice of law, and it's not, it's not any court, any state can be a forum court if they want to be, if they have some sort of jurisdiction or people before them. Well, I filed a suit against my sister because she was stealing money. That's all. So the court had jurisdiction over that issue. What they didn't have jurisdiction over was property held in trust that wasn't even in Nevada. So this judge exceeded his jurisdiction by ruling that a home in New Hampshire be sold. Well, I was never worried about this particular element because that's a simple fact that nobody can deny. Where's the house? Where's the real property in this case? It's in New Hampshire. Whoops, Nevada doesn't have jurisdiction. So I knew that one or two things would happen. I knew that the judge went way off the lines here with what he did legally as far as trusts go. But then he dotted the I because to get the money so he could pay his lawyers, he broke cashier check law. He stopped payment on a cashier's check that he declared was lost when it wasn't lost. That's bank fraud, Judge. Bank fraud. So to pay your trusty little lawyers that turn around and contribute to your campaigns, it's bank fraud. 1344. You submitted a fraudulent document to the bank as a sitting Nevada District Court judge. That's what you did. You created bank fraud. So you're amazing. Anyways, and the bank, you're amazing. Mr. Barnes, Mr. Troutman, Mr. Egan, you're amazing. You allowed Dan Carone to accept an affidavit stating, first of all, that the check was in the possession of someone out here in Nevada when they lost it, and that the check's lost, and that the money needs to be returned to Nevada. The money was never in Nevada. I've always held this check. And it's never been in Nevada. The copy of it here is, but not the check. But, you're amazing. You're amazing. Anyways, I was never worried about the appellate court because I knew they had to rule one of two ways. They had to confirm that the property wasn't in Nevada. Well, that's pretty easy. They should have been able to handle that. But you see, they have a problem because if they do that, that means that they've confirmed that this judge here in Nevada made an illegal, unconstitutional order. And because of the extra step that he took by trying to get the money here with an illegal order to start with, he wrote another illegal order saying a cashier's check was lost. That's criminal. That's a Class A felony committed by a judge under the color of law wearing a black robe. That's really, really dangerous for the state of Nevada because he represents the state of Nevada. Now, don't give me this immunity crap because the judge knew what he was doing was illegal. And you lose immunity when you knowingly break the law. You're the last person that should be breaking the law because you wear a black robe and you took an oath of office. So you're a double criminal, okay? So don't go there. But anyway, so the appellate court either had a rule that the property wasn't here or they were going to do something else. Well, what they did, and by doing what they did, they proved to me that they decided to go the other way and try to protect the judge. Well, what that does at this point is that confirms my contention that this is an illegal court. It's a criminal court. And the court itself, by breaking these laws and participating in schemes and declaring checks are lost when they're not lost, get what that is. Guess what that is? Ask your newly formed RICO department, your newly named RICO department. You know what that is, Mr. Egan, Mr. Troutman, Mr. Barnes? Do you know what that is? That's a RICO violation of the 1970 law passed by Congress. So this court out here is a corrupt court. And the appellate court, in their attempt to try to protect Nevada by what this judge did, came down with a funny ruling because they struggle. They say in this ruling, because I pointed out a precedent, a binding precedent from the United States Supreme Court, Hansen versus Deckler. They ruled that a court in Florida had nothing to do, did not have subject matter jurisdiction over trust property held in Delaware. Exact same facts as my case. The Nevada court had no jurisdiction over assets held in New Hampshire. A real home, real property, didn't have jurisdiction over that. In the Hansen versus Deckler was an issue over $400,000 worth of stock. They don't have jurisdiction over that. And guess what? The house has been sold, but this check is assets of the trust. You don't have jurisdiction over that either. So the court does not have subject matter jurisdiction. I pointed that out to the appellate court in my briefs, pointed out to the Supreme Court really, but they lowered it down to the appellate court, and the appellate court had to make some sort of an answer on that Hansen versus Deckler. So what they said was that, first of all, they said something interesting. They said, well, that Hansen versus Deckler case is about property that was situated in Florida. And I go, what? Where did that come from? The property was never in Florida. But the next line says, but the Supreme Court determined that the property wasn't actually in Florida, it was in Delaware. Why did they have that first line in there? Don't they have a word processor? Why would they put a completely false statement in a ruling and then have to contradict themselves in the next line? They're struggling. They are trying to divert your attention away from something. Anyways, they said, and this is the way the ruling came down by the U.S. Supreme Court. They determined that the property wasn't in Florida, it was in Delaware. They ended the case right there. They ruled that Florida did not have subject matter jurisdiction. Case closed. But they went on to say that because the trustee, they didn't have personal jurisdiction over the trustee, because the trustee wasn't in Florida, they didn't have jurisdiction over the trustee either. But it really didn't matter because they already proved or ruled that the court didn't have subject matter jurisdiction. And in court of law, you have to have both. If you're going to make a ruling over a thing, you have to have subject matter jurisdiction. Personal jurisdiction is irrelevant. Now, this court's struggling, the appellate court struggles, and they go on to say, but I, in my appeal, didn't raise the issue of personal jurisdiction. So I lose. Or they affirmed the fact that the court here had personal jurisdiction. I never raised that issue on appeal because it's irrelevant. It doesn't make any difference. It's like the probate court thing from New Hampshire saying that the court in Nevada assumed jurisdiction over the administration. Administration's personal jurisdiction. It doesn't matter. And at that time, when that ruling was made, this judge completely had the wool pulled over his eyes by this specious New Hampshire attorney that was just trying to get an order from him so he could go to the bank and say, see, I got an order, so pay the money to Nevada. But the order doesn't count because it's over personal jurisdiction. It's not over subject matter jurisdiction. So that lawyer's got nothing but proof that he was committing a crime. That lawyer in New Hampshire is just as guilty of 1014 and 1344 as anybody. So he's a Class A felon that needs to be prosecuted. And as does Earl out here, Judge Earl, 1344, Class A felony. So all these laws have been done. Now, What I didn't count on, I knew that the appellate court was going to do one of two things. I wasn't worried about my appeal because the U.S. Supreme Court's already weighed in. They've already established that one state cannot control property in another state, period. Where are you, Egan? Tobin, get out your dusty books. You haven't looked at your law books in a long time. That should be on the first page. That should be on the first page. I went by a school bus stop the other day. I asked an 8-year-old guy out there, he was in 3rd grade, he told me. I asked him the question, can one state control property in another state? Oh, no. That's against Penowa versus Neff. This 8-year-old told me. Geez, I go, wow, okay. Future lawyer there. I hope not. But anyways, he'll be successful whatever he does. But, you got lawyers there, supposedly they're lawyers. They probably never passed the bar. That's why they're working for the bank. They can't work in front of a court. But, anyways, I was never worried about that. What I never counted on, which was an accident, first time this has happened, the Supreme Court, April 22nd this year, just last month, comes down with an order. Wow. It appears that another district court judge here in Nevada made a ruling on a case that had been filed in Nevada that had litigants and so forth. And the ruling that this district court judge made was that there were mining claims situated in California, real property, mining claims. April 22nd, order from the Supreme Court of Nevada. Case is William Percival. You can look it up. Case number 68063. Give it a little look on your old computer there. You're going to go in and look up 4303. You should look up this case. Nevada Supreme Court, 68063. Look that one up. While you're at it, you can look up mine. That appellate court decision is fun to read too. 64896 is my case number. And that's something to read. That's funny, the way they struggle. You can see them struggling, like the U.S. District Court there in New Hampshire, struggling with this enjoyment thing and not effective yet. And I mean, oh man, it's funny. It's funny. But anyway, in this order here dated April 22nd, we agree with petitions that the district court acted in excess of its jurisdiction. Courts of one state are completely without jurisdiction directly to affect title to land in other states. And they mentioned Durfee versus Duke. Famous case, I think it was between Nebraska and Missouri, where a river had kind of changed course a little bit, and there was a dispute whether the property was actually in Nebraska or Missouri. Supreme Court weighed in and said the ultimate decision on this, which can be brought up any time because it's subject matter jurisdiction, is where is the property actually located. And actually, because of a riverbank involvement, this might change it. That property might be in Nebraska today and in Missouri tomorrow. So, that's one of those gray areas that kind of like, where is the property? But my point is, it always boils down to, where is the property? And in my case, the property, there's no question about where it was. It was in New Hampshire. End of case. Case closed. I'll read this again. The courts of one state are completely, the Nevada Supreme Court added in completely. That's important because they're completely without jurisdiction to directly affect title to land in other states. Durfee versus Duke. Look up that one if you want. Anyways, this was a bonus for me because this is a current order, just came down less than a month ago. So this proves my point that this court in Nevada had no jurisdiction over New Hampshire property. So this case out here is closed. It's done. It's been done, and I could have raised the issue at any time as far as the Supreme Court ruling goes in Hansen versus Deckler, and go back to the U.S. District Court in New Hampshire. And if I have to go to the First Circuit, I can go to the First Circuit because they've already ruled that cashier's checks have cash equivalency. So basically, you guys are sitting on a bad situation. But it gets worse because under CUTPA laws, CUTPA in Connecticut is pretty strong law. And the provisions of it, look it up there, Mr. Egan, while you're over there looking up these other things. Look up Cutler under 42A 110G. Look that baby up, okay? There's provisions in there that if you sell a customer in the state of Connecticut, something like this right here, the cashier's check. See that cashier's check? And this, notice to customers, before we do anything about replacing this check, you may be required to put up an indemnity bond. Okay, well, that's pretty strong language, has a reason for that. So when you sell a product like this from your bank, that comes under consumer protection laws, Consumer Unfair Trade Practice Acts, CUTPA, look it up. 42A, 110G, look it up, okay? Enjoy, because it's going to cost your bank a lot of money, because the provisions in there are that I'm entitled not only to the payment of the check, all fees, interest, expenses, whatever else, and some really things you should be interested in, treble damages, okay? It also goes on to talk about punitive damages, because it's very important in this particular type of a case. Bank checks are not just something that I happen to have here. I'm just one person, one family that got the 50-year-old house ripped out from underneath of them because of a corrupt judge, and then worse, a corrupt bank participated. Do you realize if you hadn't sent the money to Nevada, none of this would have ever gone on? I wouldn't have appealed the case because the judge couldn't have paid his lawyer buddies. The only reason I appealed this is because the judge was illegally awarding obscene legal fees of hundreds of thousands of dollars to lawyers that he's not entitled to do. Nobody in a spendthrift trust has any money. You can't award anything from something that somebody doesn't have yet. And a judge can't do that. Look up spendthrift trust while you're at it, Egan, whatever your name is. I mean, you're not a lawyer. You may have gone to law school, but good God. You need to try to pass the bar. Maybe you need to go back and study a little bit. I don't think you'll pass the bar. But anyways, that's where we are. Now, these CUTPA laws, punitive damages. You might be subject to some very severe punitive damages because, think about it, they have to punish you. What do you do to a $45 billion bank to punish them? $1 billion? $2 billion? I don't know. Might be up to the judge to decide. And depending on how much flack is going to come in on this case from the business of commerce, the Senate, Congress, what have you, they pass these things and these regulations and so forth in the commerce, business of commerce. It's very important, and all courts usually have weighed in about the extreme importance of these cashier's checks, how important they really are when it comes right down to their integrity. And the entire banking industry, their credibility. Why do you put money in a bank? Willie Sutton says, because that's where the money is. Well, maybe not. But one good thing about the cashier's check that Travis told me to get, if I'd gone back to the bank with my trusty cashier's check, and Willie Sutton had just been there and took all the money, guess what? The bank still has to pay my check. So those checks are supposed to be safe, but they're only safe as good as what the bank is. Your entire integrity of People's United Bank is in jeopardy, and I'm going to do whatever is in my power to make sure that that word gets out there. I'm going to publish this on YouTube. It's being recorded right now. It's being streamed live, and that'll be available. Anyone can look it up. And I do these things all the time, and I'm going to be doing, I'm going to stream another one as this progresses, and I'm going to be going to a lot of things, a lot of activities going to start coming down the pike. There's a newspaper here in town, the Las Vegas Tribune, has written about 36, maybe going on 40 articles about this very case. And the reason the editor is so interested in this particular story because it has such far-reaching tentacles to it. The entire banking industry, the integrity, People's United Bank may be famous someday. You've been responsible for the collapse of the cashier check business in this country. I asked a senator the other day, I said, if something should happen to where banks can't issue cashier's checks anymore because they're no longer reliable because of People's United Bank, I said, how are any businesses going to close? Are people going to have to drive around with tractor trailer full of money? How do you close $1 billion deal? How many trucks do you need? I mean, Jesus Christ, it'll bring the commerce business to a grinding halt. I mean, God, think about it. This is ridiculous. Your People's United Bank and your RICO department with Egan and Troutman, you guys and Barnes, you better take a close look at what the hell's going on over there. Because this isn't just about Feeley anymore. This is about the entire banking industry. And our cashier's check's going to be accepted anymore. Well, we're going to have to make a big point that, well, here's why. Because a federal court ruled punitive damages against People's United Bank was so significant that that would get the attention of all the banks and put a big exclamation point again for banks that already knew you should never stop payment on a cashier's check or you're in a minefield. Go online, you'll see it all over. Do not stop payment on a cashier's check. You can't do it. Every bank knows that. I talked to another bank there in New Hampshire, president of the bank. He told me he's never heard of a bank in New Hampshire stopping payment on a cashier's check. Maybe that's because this bank, particular branch, is headquartered in Connecticut. Maybe that's why. Yeah, maybe the Connecticut system is so corrupt. Who knows? But I know the judiciary in Connecticut's got a ranking of an F, just like Nevada does. F. You know, of course, most states have an F in their judicial because the judiciary is so corrupt. It's corrupted. Money has corrupted the judiciary. No longer do you get a ruling according to the law. You get a ruling according to which lawyer contributed the most to the campaign of the judge in the states that still allow judges to be elected. Nevada has that. There's a movement underway here now that I've caused that's going to have that looked at very closely, and there's stuff pending now that's going to be brought up at the legislature to change that. And this is going to be one of the poster childs of why. So again, maybe People's United Bank, you'll get some publicity off of this. They say, well, all publicity is good publicity, whether it's good or bad. Is that really true in the banking business? Let me ask your stockholders. Is that really true if you get associated with a RICO violation or stopping payment on a cashier's check? Is that something that the bank should be behind because, all publicity is good? We'll find out. Are you listening, Mr. Barnes? We'll find out. I promise you, I don't go away. I will find out where this leads to, and it's not going to be good for the bank. And the other thing you need to consider very carefully is that these damages are mounting up every day. Are you listening, stockholders? Every day your liability is increasing. So your liability in this is not going away. Are you listening, Mr. Egan? This appears to not be over. How about that? How can, Mr. Barnes, how can you have someone working in your formerly called legal department by the name of John Egan that told me in an email, I have it, where he says they consider this matter closed? Oh, okay, well that's it then, I guess, I'm done. You know, how can that guy be a lawyer when he considers a matter closed? Let me tell you something, Mr. Egan, are you listening? This matter will never be closed until the law of this land is upheld and until this cashier's check over here is paid in full now with treble damages, interest, expenses, everything else, and the interest is going up every day, as are the damages. So this will never be settled until that is paid. Okay, Mr. Egan, just so you know. You can bring that up when you're back in law school. You can ask them that question. When are things really over? Ask yourself that. Okay? Well, anyways, my voice is leaving me. I'll be back with future broadcasts, live streams to YouTube. I hope you pay attention because you refuse to meet with me. Why? I have this check over here. See this check, boys? Barnes, everybody over there in the bank, the stockholders, the board of directors, this check issued from you. You have to stand behind it. There's no expiration on this check. It's good forever. There's no time limit on it. So you guys are going to have to pay the check. The sooner you pay it, the better off you're going to be. You know. So let's get after it. Let's get something going here. You better get a hold of me. You can get a hold of the Las Vegas Tribune. They know where to find me. They interview me often for these stories they write. So I'm around. They know how to get me. And matter of fact, you can look up online. Just go to Google Feeley and Las Vegas Tribune, and 30 or 40 stories will pop up that have been published here. And they're online. They're all over the world. So it's going to go on. This is going to be known. So I'm going to get you all the publicity I can possibly get for you guys. It's going to be known that you're a despicable bank, that you steal from the dead. Anyways, I'll sign off for now. Call the Las Vegas Tribune. Let's get to the bottom of this, because you're going to have to meet with me sooner or later. Sooner the better. Believe me. You don't want to meet me in front of a jury. See you later.